That kid, Julian Pollock, is a Berkeley kid, grew up in Berkeley. I used to listen to him play when he was in high school. I don't know whether he's got much of a career going now, but he was great in high school. Four members of the class are over in the Ninth Circuit Court of Appeals scouting the in-bank argument in the minority TV case, and I hope they'll be able to report to us on Thursday what that's all about. I should have your midterms all graded by tonight and post the scores and pick up the test forms on the corrected forms on Thursday. I should have said about the common law of libel that this is not ancient history. This is not a relic of the past. The common law rules are alive and well today and important, largely for the reason that if a plaintiff who wants to sue a publisher for libel wants to win, the plaintiff has to allege and prove those common law elements today, just as he or she did back in the pre-Sullivan days. As we'll see, the Sullivan case superimposed on the common law rules of libel First Amendment rules. But in many cases, defending against a claim of libel is quicker, cheaper, and easier if you use the common law rules than if you say, well, you have to prove constitutional fault and so on. For example, if it is clear that the defamatory statement is not of and concerning about the plaintiff, the case is over, right at the courthouse door. No trial, nothing further needed. Or, as in the Dorsey case, where a common law privilege, like the fair report privilege, protects the alleged libeler, case is over. Summary judgment, the case is kicked out. And that's much easier on the press than having to defend on the ground that what was published was truthful. And the weaknesses in the common law protection, largely putting the burden of proving the truth on the defendant, and the fact that libel at common law was a no-fault tort, where the plaintiff didn't have to prove that the publisher knew it was false, wanted to hurt the plaintiff, whatever kind of blameworthy state of mind that the publisher might have had, that wasn't necessary, making it much easier for libel plaintiffs to prove their case at common law than after Sullivan. So let's turn to Sullivan, which is, in my view, the most important case in American history on the meaning of the First Amendment guarantees of freedom of speech and the press. There's a wonderful book about the case, Make No Law, written by Anthony Lewis, the former New York Times columnist and longtime Supreme Court reporter for the New York Times. The book Make No Law, which should sound familiar to you, is about not just the Sullivan case itself, taking it apart in every detail, how it got there, what it means, but it's a succinct, readable history of free speech and freedom of the press in this country. And if you got time on your hands over spring break, pick it up. It's in paperback. It's a great read. Well, the Sullivan case began in the early days of the civil rights movement in the South, when a bunch of civil rights activists took out a full-page ad in the New York Times, paid advertisement, in support of trying to raise money for Dr. Martin Luther King and his efforts in the South to desegregate public schools, public transportation, to do away with racial segregation in the South. And the ad was taken out by a bunch of prominent people. Eleanor Roosevelt, this is Eleanor Roosevelt, there's Harry Belafonte, Jackie Robinson, a whole bunch of celebrities, movie stars, prominent people who got together and paid for this ad to support Dr. King's struggle in the South. The ad is, it's got 6 paragraphs, something like that. The 3rd paragraph and the 6th paragraph are what the libel suit was all about. It's about demonstrations in Montgomery, Alabama, the heart of the Confederacy. And the ad says, in Montgomery, Alabama, after students sang "My Country 'Tis of Thee" on the state capitol steps, their leaders were expelled from schools, and truckloads of police armed with shotguns and tear gas ringed the Alabama State College campus. And then the dining hall was padlocked to punish the students and starve them, the demonstrators, starve them into submission. And then in the 6th paragraph, the one that starts again and again, the ad is in the reader if you need to look at it carefully. It says, the Southern violators have answered Dr. King's peaceful protests with intimidation and violence. They bombed his home, almost killing his wife and child. They've assaulted his person. They've arrested him 7 times. He's now charged with perjury and so on. This is what the Southern violators had done in an attempt to squash the civil rights movement led by Dr. King in Alabama. Well, after the ad was published, the New York Times circulated, I don't know, a few dozen at the most copies of the newspaper in the state of Alabama. And somebody brought to the attention of L.B. Sullivan, the chief of police, basically, of Montgomery, Alabama. It's the only picture of him I could find. He looked a little thuggish, and was, in fact, but he was the chief of police in Montgomery, and somebody showed him a copy of the ad. I'm confident that he was not a regular reader of the New York Times, but he saw the ad and decided to sue the New York Times for libel, filing a complaint saying that this ad accused Sullivan of leading this campaign of brutal suppression of the civil rights demonstrators in Montgomery, suppressing their constitutional rights to protest and to have equal facilities and so on. And he sought $500,000 in damages. The Times attempted to get rid of the case before trial on motions to dismiss. Those were unsuccessful. They were up against an ardent segregationist judge. Then the case was called for trial, and the case was tried before an all-white jury in Sullivan's hometown of Montgomery with predictable results. The trial judge, Judge Walter Jones, instructed the jury that the accusations in the ad were libelous per se, libelous on their face, because they accused at least Southern violators of illegal, unconstitutional acts to suppress the civil rights demonstrations, and that criticized the Southern violators for violating the public trust, for violating their oath of office of acting wrongfully in their occupation, and therefore they were libelous per se. Under the common law of Alabama and the common law everywhere, defamatory statements were presumed false, so that truth was a defense. The plaintiff was not required to prove the falsity of the allegations of the statement, and damages were presumed. That is, the plaintiff did not have to prove out-of-pocket losses, actual damages of any kind. Damages were presumed, and a plaintiff could recover damages for embarrassment, humiliation, loss of good name, reputation, and so on, and ask the jury to award money damages for that. And the only significant issue presented to the jury by Judge Jones was whether the ad could be considered of and concerning Sullivan, because it didn't mention him. And what he did to attempt to persuade the jury that the ad defamed him was call 6 of his cronies from Montgomery, who came in and testified that when they saw the ad, they weren't subscribers either, but when they saw the ad and they saw the accusations about what the police had done, and then the reference to Southern violators seeming to refer back to what the police had done, they immediately associated that with L.B. Sullivan. He was the chief of police, after all. And they made that connection as soon as they saw the ad. And Sullivan himself testified that he thought he was being accused in this ad. So the case was sent to the jury with instructions from Judge Jones. You need to determine whether the ad was of and concerning Sullivan and the amount of damages. And that was basically it, because it was defamatory per se, libelous per se. There was no privilege that would apply. And the only question for the all-white jury was it about Sullivan? How much of the damages? And sure enough, to no one's surprise, the jury promptly came back with a verdict in Sullivan's favor for the amount requested, $500,000. The Times had, of course, at the outset of the case, raised a First Amendment defense that it could not be held liable for this ad, consistent with the First Amendment, that the First Amendment, as applicable to the state of Alabama through the Due Process Clause of the 14th Amendment, precluded liability in this case. Well, the Times appealed to the Supreme Court of Alabama. We're in the state court system. Libel is purely a state law claim, common law, state law claim. So the Times appealed to the Supreme Court of Alabama, which summarily dismissed the First Amendment argument that the Times made, saying that libel has never been protected by the First Amendment, citing several statements to that effect by the United States Supreme Court. That libel was, as we know, a category of speech that is not protected by the First Amendment at all. And as for the Times appeal on the of and concerning point, whether the libel was of Sullivan, the Alabama Supreme Court said, in effect, it's common knowledge that criticism or praise directed at a government agency, like the police department, is taken by readers to mean criticism or praise of the person in charge. And therefore, it's reasonable to say that the of and concerning requirement was satisfied because criticism of the police could be taken as criticism of Sullivan personally. Therefore, judgment affirmed. The $500,000 verdict stands. The Times petitioned for certiorari in the Supreme Court. The court granted certiorari and heard argument and decided this wonderful case, New York Times versus Sullivan in 1964. And I'd like to approach the analysis of the case in looking at it 4 different ways. First, let's look at it as a common law case. How did it stack up as a matter of common law, whether the elements of the common law were met or not? Secondly, what the Supreme Court found wrong with the common law of Alabama as applied in this case that made it necessary for the court, for the first time in history, to impose First Amendment requirements in a libel case. Third, we'll look at the court's holding, exactly what the court decided with the newly constitutionally mandated rules for libel. And fourth, look at the alternatives that the court might have used that would have served much the same purpose without some of the difficulties caused by what the court did do. What the court ends up with, of course, is establishing First Amendment protection for at least some speech that is false. So look at the common law elements first. And how did the Sullivan case stack up? Well, with regard to falsity, that we know was not a problem for Sullivan, because if this defamatory statement had been published, he doesn't have to prove that it was false. Proving the truth is a matter of the defense. The burden's on the defense. And it turned out that the ad was not true in every particular. For example, the student demonstrators actually sang the Star-Spangled Banner, not My Country 'Tis of Thee. Well, big deal. Some of the students were expelled, not for the demonstration that they were involved in, but for a separate lunch counter demand that they had made. The dining hall was never padlocked. to starve the students into submission or otherwise. The police did not actually ring the campus. They were deployed nearby. Martin Luther King was arrested only 4 times instead of 7, as alleged in the ad. And Sullivan, if the ad was about Sullivan, had nothing whatever to do with the perjury indictment of Dr. King. So defamatory meaning? Yeah, the judge was correct. This accused public officials, assuming it was about them, of misconduct in office. It tends to injure them in their profession and in their occupation. In fact, in the real world, Sullivan's reputation in the community that he cared about, the white segregationist community in Alabama, his reputation was undoubtedly enhanced if he was beating up on civil rights demonstrators rather than being nice to them and facilitating the demonstrations. But legally, the judge was correct. Accusing a public official of unconstitutional conduct, misconduct in office, certainly is libelous. Was the publication element of the common law rules met? Yeah. Clearly, the Times published the ad. There was no doubt about that. But not one word in the ad was written by the New York Times. It was not their editorial product. They were not the authors of the ad at all. The paid-for ad taken out by these other folks. Does that get the Times off the hook? No. As we saw last time, under the common law, republishing somebody else's libel, the libel uttered by the first speaker, makes you as liable for libel as the original speaker. And the fact that it's not your words, that you've accurately quoted somebody else's words, does not get you off the hook. The big issue, of course, was whether the ad was to be legally considered of and concerning L.B. Sullivan. He was not named in the article, in the ad. It wasn't readily identifiable from the context, but he was able to rely on the testimony of these witnesses that they made the connection between the ad and Sullivan. And then he got the big assist from the Supreme Court of Alabama and its newly announced rule that criticism of a government agency can be taken as of and concerning the head of the agency. So, and then as I say, damages, he didn't have to prove damages. And he wasn't, in fact, damaged in any way. But he didn't have to prove that. There was no privilege that the Times could assert to defend, that it wasn't, the ad was not a report of a judicial, legislative, or other governmental proceeding, a trial, or something happened on the floor of the legislature. It wasn't that at all. And it wasn't a matter of opinion that might be protected by the fair comment privilege. So neither of the privileges that we know about would be applicable here. And finally, under the common law, Sullivan didn't have to prove any fault by the New York Times. That is, he didn't have to prove that they knew it was false, that they intended to hurt Sullivan, nothing of that sort. At common law, no fault was required. So his case as a common law case is barely plausible on a couple of the elements, but could sneak in, and did. And that left the Times with its constitutional argument that imposing liability in a case like this that involved criticism of a public official in the conduct of his public duties was constitutionally protected, even though it may have been false in some respects. So then let's look at what the court found wrong with the common law of Alabama that caused the court to impose First Amendment limitations on how the states can protect their citizens' reputations from libel. In general, what the court found wrong were 3 things. One, that what Alabama did was impose a test of truth on criticism of public officials, on political speech. That is, the speech was not protected if it turned out to be false. But the court said, and this is the most quoted passage in the Sullivan case, we consider this case against the background of a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open, and that it may well include vehement, caustic, and sometimes unpleasantly sharp attacks on government and government officials. It's that in that robust public debate about the issues of the day, that uninhibited debate, the court said, error is inevitable. Mistakes will be made. Falsity will be uttered. Does that mean that it's unprotected? And the court said it can't be, because the press and freedom of speech need some breathing space. Otherwise, there would be an intolerable chilling effect on truthful speech. If you can't be sure, when you publish, that you will be able to spend the money, find the witnesses, and take the time to prove the truth, then you're not going to publish. And a lot of truthful speech will never be heard if the test of truth is imposed on political speech. The press and other speakers will, as the court said, steer clear of the prohibited zone where falsity lies. And that's especially true, the court pointed out, where the burden is on the publisher to prove the truth. So the court concludes that the fact that a statement that is published is false is not by itself a sufficient